This is to advise the general public that in compliance with Chapter 231 of the Public Laws of 1975, entitled Senator Byron Bear Open Public Meeting Act, New Jersey Casino Control Commission on December 10, 2025, filed with Secretary of State at the State House in Trenton the annual meeting schedule. On December 10, 2025, copies were mailed to subscribers. The use of cell phones in a public meeting room while the commission is in session is prohibited. Any member of the public who wishes to address the commission will be given the opportunity to do so before the commission adjourns for the day. Please stand for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all.
Good morning. Welcome everyone who is joining us in person and remotely today. Meeting participants who wish to do so can continue to address the Commission through remote technology. We are also permitting in-person participation, and the public meeting room is therefore open. We will, however, continue to stream our public meetings. The public is able to listen through access provided on the Commission's website, as well as through our YouTube channel. We will accept public comments via email. Public comments can be sent to public.comments@ccc.nj.gov beginning now. I will repeat that. Public comments can be sent to public.comments@ccc.nj.gov beginning now and any time throughout the meeting, ending at the time of adjournment. This meeting is being transcribed as well as recorded, and minutes will be available on our website in due course. To meeting participant callers, I ask that you follow the instructions provided with the web link or audio call-in code, and place your phones on mute until your matter is called. Also, when your matter is called, please turn on your camera and identify yourself before speaking. Thank you.
Please answer when I call your name for the roll. Commissioner Formica?
Here.
Vice Chair Molyneux?
Present.
And Chairman Floses?
Here.
Matters discussed in closed session this morning included employee key license application matters, as well as approval of the amendments to the software assets reporting policy within the Commission's Personnel Policy and Procedure Manual, and approval of the amendments to the following policies within the Commission's Personnel Policy and Procedure Manual: the discipline policy, the resignation and retirement policy, the leaves of absence policy, overtime policy, and accident reporting policy. And finally, approval of the closed session minutes of the June 10, 2026 closed session. The first item on the public agenda for your consideration is ratification of the minutes of the June 10, 2026 public meeting.
Are there any questions for council or corrections?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I make a motion to ratify the minutes of June 10th, 2026.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Item number 2 are consideration of applications for resubmitted casino key employee licenses and/or for qualification. The list includes Gloria D. Brown, Kevin M. Intris, Andre E. Harvey, Thomas W. Hoskins Jr., Chow K. Lam, Peter R. Massaroni Jr., Elizabeth Matos, also known as Elizabeth Negron Torres, Vipul R. Pandya, Maria L. Pichowski, also known as Maria L. Alberts, Maria L. Stepanowicz, Anthony Rio Jr., Brenda Schaffman, also known as Brenda Gonzalez, Trevor R. Sterling, Angela Tarnicki, also known as Angela Newsy, Angelica M. Trosh, Nelson V. Velez, Thomas L. Vo, also known as Tung T. Vo, and Karen E. Warman, also known as Karen E. King. There are 4 separate votes required and recommended under item number 2. The first vote would be those resubmissions that have been reviewed by the division with no objection and by commission staff with the recommendation that they be granted. Those include Gloria Brown, Kevin Interest, Andre Harvey, Thomas Hopkins Jr., Peter Massaroni Jr., Elizabeth Matos, Vipul Pandya, Anthony Rio Jr., Brenda Schaffman, Angela Tarnicki, Angelica M. Trosh, Nelson Velez, and Thomas Vo, for a total count of 13.
Are there any questions regarding any of these matters?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I make a motion to grant the 13 resubmitted casino key employee license. For the record, I reviewed Assistant Director Ehler's memo and the division's reports, voicing no objection.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye.
Aye.
Opposed, the ayes have it.
The next resubmission for your consideration is I, Maria L. Pikowski. She is called separately to facilitate a vote on 2 license cycles. Her matter has been reviewed by the division, who raises no objection, and commission staff also recommends that her resubmitted casino key employee license for the 2 cycles be granted.
Are there any questions of council on this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. At this time, I move to grant the resubmitted casino key employee license application of Maria Pikowski for 2 cycles, 2 license cycles, February 2021 through February 2026, and February 2026 through February 2031.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye.
Aye.
Opposed, ayes have it.
Thank you. The next vote under item number 2 are for Chan K. Lam and Trevor R. Sterling. Their resubmissions requests also include requests for multi-casino endorsements with respect to Mr. Lamb for Caesars, Harris, and Tropicana, and with respect to Mr. Sterling for Caesars, Harris, Tropicana, and Caesars Interactive Entertainment, New Jersey. Again, their resubmission applications have been reviewed by the division, who raised no objection. Commission staff also recommends that their resubmission applications with MCEs be granted.
Are there any questions for council regarding either of these matters?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. At this time, I move to grant the 2 resubmitted casino key employee licenses with multi-casino endorsements pursuant to NJSA 5:12-91.1, and that would be for Chow Lam and Trevor Sterling.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
Hearing none, all in favor say aye.
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 Opposed, ayes have it.
And the last vote for number 2 is for Karen Warman. Her resubmission application also includes continued qualification to serve as Vice President of Finance Regional for Boardwalk Regency LLC, Harris Resorts Atlantic City, and Tropicana Atlantic City Corp. Again, her resubmission application has been reviewed by the division, no objection. Commission staff also recommends that her resubmission with MCE and continued qualification be granted.
Are there any questions regarding this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. At this time, I move to grant the resubmitted casino key license of Karen Warman with a multi-casino endorsement pursuant to NJSA 5:12-91.1 and qualification.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Item number 3 are approvals through delegation of authority between June 1, 2026 and June 30, 2026 pursuant to resolution number 2602-1116D. You have Manager Harry Jeeves here to review those action items with you, but no commission action is required at this time.
Good morning, Chairman and Commissioners.
Morning.
Morning.
For the record, I'm Harry Jeeves, Manager of the Commission's Licensing and Financial Evaluation Unit. Between June 1st and June 30th, the staff of the Commission's Regulatory Affairs Division granted the following approvals via its delegated authority. On June 8th, a temporary casino key employee license was granted to Salika P. Batista for a dual-rate slot services supervisor/shift manager position at Caesars. On June 16th, a temporary casino key employee license was granted to Sean M. McGettigan for a dual-rate surveillance operator/surveillance supervisor position at Ocean. On June 18th, a temporary casino key employee license was granted to Michael O. Stallings for an assistant surveillance supervisor position at Resorts. On June 23rd, a temporary casino key employee license was granted to John W. Jarvis for a dual-rate casino game supervisor/assistant casino shift manager position at Caesars. On June 24th, a temporary casino key employee license was granted to Amira T. Blackwell for a security shift supervisor position at Resorts. And on June 26th, a temporary casino key employee license was granted to Stephen M. Bergman for a dual-rate casino supervisor/assistant casino shift manager position at Golden Nugget. This memorializes the approvals that were granted by the Commission's Division of Regulatory Affairs via its delegated authority during this period. No further Commission action is required. Thank you.
Thank you.
Item number 4 are requests for inactivation of casino key employee licenses. Again, we have Manager Harry Jeeves to review those matters with you.
In lieu of filing a casino key employee license review application, Howard P. Bruno, Peggy A. Bunch Morgan, also known as Peggy A. Bunch or Peggy A. Morgan, and Robert A. Rosenthal have requested to be placed on the casino key employee license approved inactive list. If the requests are granted, these individuals may remain on the approved inactive list for a period of up to 5 years. Commission staff has reviewed the request and recommends that you grant the requested relief.
Are there any questions regarding any of these matters?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I've reviewed the memo of Mr. Givas, and at this time I move to grant the requested relief and order that the 3 casino key employee licenses as detailed be inactivated.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
sir.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Item number 5 is consideration of the lapsing of certain casino key employee licenses. Again, we have Manager Harry Jeeves to review that with you.
Thank you. For your consideration is the lapsing of the casino key employee licenses of the following individuals for failure to file a casino key employee license review application or request to be placed on the casino key employee license approved inactive list. Joseph A. Corbo Jr., Gloria J. Edwards, Christy L. Harker, Joseph T. Lodice, and Laura M. Tyson. In each case, the due date for filing a casino key employee license has passed. Based on staff's review, we recommend that the casino key employee licenses of the noted individuals be deemed to have lapsed.
Are there any questions regarding any of these matters?
No, sir.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I've also reviewed Mr. Givas' memo in this matter, and at this time I move to find that the 5 casino key employee licenses lapsed pursuant to NJAC 19:41A-6.1F of the regulation.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
sir.
Hearing none, all in favor say aye.
Aye.
Opposed? Ayes have it.
Thank you. Item number 6 is consideration of the resubmission application of Phuong Tran for a casino key employee license. That matter is docketed as docket number 0083SR. You have Senior Counsel Teresa Pimpinelli, who will review it with you.
Morning, Chairman and Commissioners. Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is a stipulation of settlement for the resubmission application of Huang Tran for her Casino Key employee license. If approved, Ms. Tran will be licensed through January of 2030. You have staff's memo and recommendation for this matter. Ms. Tran was notified of today's proceedings and is here to answer any questions or address any concerns you might have. I would ask counsel for the division to enter their appearance and proceed.
Good morning, Chairmans and Commissioners. Jocelyn Fedowitz, Deputy Attorney General on behalf of the Division of Gaming Enforcement. You have the division's report along with the stipulation of settlement that has been entered with Huang Tran. The division respectfully requests that the stipulation be approved as submitted and recommends the continued Casino Key employee licensure of Huang Tran, subject to the terms and conditions in the stipulation. Thank you.
And for the record, the applicant is not present.
It's the applicant.
Here.
This is the
Oh,
applicant.
I'm sorry.
Hi.
Morning.
Good morning. How are you?
Morning.
Did we want to swear her in?
If she wants to say anything.
Did you want to make a statement?
Yes.
Okay.
Please
Could
stand
you
over here.
adjust her mic closer to her?
You have to be sworn in.
Ms. Tran, please stand, raise your right hand.
Yeah.
Raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I'm so nervous. I'm so sorry.
Just say, respond. Yes or no?
Yes.
Yeah, Thank you. You can be seated.
Yeah.
You're not,
Just a
you're not,
little
requ-
closer to you.
you're not required to say anything if you don't want to.
Okay. Yeah. Right now, I can't think.
Are there any
anything.
questions
Yeah.
for counsel or the applicant?
I have none.
No. You're good?
Okay.
Hearing none, do we have a motion then?
Yes, sir. Thank you, Mr. Chairman. I have reviewed senior counsel's memo, the stipulation, the division's reports, and at this time, I move to approve the stipulation of settlement between the division and the applicant to grant the resubmission application of Huang Tran for a Casino Key employee license, subject to compliance with the terms and conditions as provided for in the stipulation.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
Hearing none, all in favor say aye.
Aye.
Aye. Opposed? Ayes have it. Thank you.
Thank you.
Thank you, ma'am.
Okay.
Thank you.
Have a good afternoon. Thank you. Item number 7 is consideration of the initial application of Francis Abano for a Casino Key employee license. That matter is docketed as docket number 260038CK. Again, we have Senior Counsel Pimpinelli, who will review it with you.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the Commission again. For your consideration is the initial application of Francis Abano for his Casino Key employee license. You have staff's memo and recommendation for this matter. Mr. Abano was notified of today's proceedings. I would just ask counsel for the division to enter their appearance and proceed.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General on behalf of the Division of Gaming Enforcement. On March 6, 2026, the division filed a letter report recommending that the application of Francis Abano for Casino Key employee licensure be denied pursuant to Sections 80B, 80D, 89B1, and 89B2 of the Casino Control Act. Subsequently, the Commission at its May 13, 2026 meeting remanded the matter to the contested case process. As advised by the Commission, Francis Abano failed to submit the requisite hearing request form and comply with the contested case process. Therefore, based on the applicant's non-responsiveness and failure to comply with the contested case process, as well as the issues raised in the division's report, the division requests that Francis Abano's application for Casino Key employee licensure be denied. Thank you.
Thank you. And for the record, Mr. Albano is not here?
Correct.
Okay. Are there any questions regarding this matter?
No.
I have a question for counsel for the division.
Yes.
Ms. Fedowitz, did I read this right? It looked like you asked this guy for retirement documents, security account statements, bank account statements, information regarding large deposits and withdrawals, information regarding past due credit cards, personal loan information, information regarding an IRS debt, copies of a spouse's income tax returns, tax information on the claiming of children on returns, purchase and loan agreements for vehicles, and information on his current residence, and he didn't supply any?
Correct.
That's it.
Okay. Any other questions?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed senior counsel's memo, the division's reports. I've also got some information from counsel for the division. At this time, I move to find Francis Albano disqualified pursuant to NJSA 5:12-80B and D, NJSA 5:12-86, NJSA 5:12-89, and deny his application for a casino key employee license.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
sir.
Hearing none, all in favor say aye.
Aye.
Opposed, ayes have it.
Item number 8 is consideration of the resubmission application of John Brady IV for a casino key employee license. That matter is docketed as docket number 260039CR. Again, Senior Counsel Pipinelli will review that with you.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is the resubmission application of John Brady IV for his casino key employee license. You have staff's memo and recommendation on this matter. Mr. Brady was notified of today's proceedings. I would just ask counsel for the division to enter their appearance and proceed.
Chairman and Commissioners, Jocelyn Fedowitz, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. On March 6, 2026, the division filed a letter report recommending that the resubmission application of John Brady for casino key employee licensure be denied pursuant to Sections 80B, 80D, 89B1, and 89B2 of the Casino Control Act. Subsequently, the Commission at its May 13, 2026 meeting remanded the matter to the contested case process. As advised by the Commission, John Brady failed to submit the requisite hearing request form and comply with the contested case process. Therefore, based on the applicant's non-responsiveness and failure to comply with the contested case process, as well as the issues raised in the division's report, the division requests that the resubmission application of John Brady for a casino key employee licensure be denied and John Brady's casino key employee license revoked. Thank you.
Again, for the record, the applicant is not here.
Correct.
Thank you. Are there any questions regarding this matter?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I've reviewed senior counsel's memo, division's reports, the recommendation. At this time, I move to find John Brady IV disqualified pursuant to NJSA 5:12-80B and D, NJSA 5:12-86B, NJSA 5:12-89B. Also to deny his resubmission application for a casino key employee license and revoke his casino key employee license.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, all in favor say aye.
Aye.
Opposed, ayes have it.
Item number 9 is consideration of the initial decision in the matter of the appeal of E.G. for removal from the self-exclusion list. That matter is docketed as 250189AP. And again, we have Senior Counsel Pipinelli who will introduce that matter to you.
Chairman, Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is the May 28, 2026 initial decision of hearing examiner Molyneux in this matter. This matter is an appeal from the Division's October 21st, 2025 final agency decision denying EG's request to be removed from the self-exclusion list prior to March 7, 2030. After considering all the available evidence and given the facts of this particular matter, hearing examiner Molyneux found that appellant should be removed from the self-exclusion list after March 7, 2026. You have the complete record in this matter, all of which is subject to the applicable confidentiality and privacy requirements. Appellant was notified of today's meeting. I would ask counsel for the division to enter their appearance and proceed, and I respectfully remind all parties that appellant's identity is confidential.
Good morning, Chairman, Commissioners. Gina Dianantis, Deputy Attorney General, appearing on behalf of the Division of Gaming Enforcement.
Good morning.
You have received my letter exceptions. I have a few points I would like to highlight from those. The purpose of NJAC 13:69G-2.3 is to ensure that all internet gaming operators receive the updated self-exclusion list and information from the division and have a defined period to update their systems. The division has been delegated the authority to maintain the self-exclusion list and to notify the casino licensee whenever someone is added to the list. Each casino licensee must maintain its own copy of the list and update it within 24 hours for all internet self-exclusions. For land-based self-exclusions, they have 5 days to update the list. As Chairman Pelosi is aware from sitting on the governor's Responsible Gaming Task Force, there is a slight delay in all operators being noticed of the self-exclusion. A delay which the Responsible Gaming Task Force found acceptable and did not recommend any changes to that system or to the process. The material facts here are not disputed. On March 6, 2025, the appellant voluntarily self-excluded and completed every step necessary to enroll in the Internet Self-Exclusion Program through FanDuel for a 1-year term. On the following day, the same appellant voluntarily enrolled again through the Jackpot City application, this time selecting a 5-year term. The Internet Self-Exclusion Program exists to protect patrons by enforcing the exclusion period that they voluntarily choose. This appellant chose to self-exclude on 2 separate occasions and for 2 separate terms, and went through the entire process both times and indicated on the record that he did not read through any of the process and that he was simply clicking through. He just wanted to get through it as quickly as possible. The regulations do not authorize the division to disregard a later valid self-exclusion request simply because an earlier request selected a shorter period. Nor do they require the division to ignore a patron's subsequent voluntary election. To the contrary, once the appellant submitted a valid 5-year request, the division had an obligation to administer the program consistently. The hearing examiner repeatedly focuses on what is perceived as an ambiguous regulation. However, the absence of a regulation specifically addressing multiple voluntary enrollments does not invalidate the division's program. The division is not ignoring the 1-year self-exclusion term. Rather, the division is simply applying both terms, which is reasonable and consistent with the protective purpose of the self-exclusion program. Allowing patrons to later argue that an earlier request should control would undermine the certainty and reliability of this program. The process. A person self-excludes. The operator then sends the list to the division in the morning. At approximately 10:45 every morning, the division confirms the new list that is received and makes the self-exclusion list. At noon, the internet providers are given the list. Once that is received by the internet providers, they have 24 hours to update their system and to suspend patrons from accessing their gaming accounts. Therefore, the timeline in this present matter was all within the regulations. The 24-hour implementation requirement prevents against delays by operators. And for the patron to be immediately locked out of their gaming account is not feasible. The division needs to alert approximately 29 operators of this new self-exclusion, which would be totally unrealistic to do immediately. There's a process that needs to be followed, and that process was followed correctly here, all within the regulation. The appellant was not compelled to submit the second request. He did so voluntarily. Interpreting the regulations to invalidate a later voluntary 5-year self-exclusion simply because the patron later regrets their decision would frustrate the purpose and invite uncertainty into the administration of this program, and additionally is not consistent with prior precedent set by this commission. More specifically, Commissioner Formica, you were very clear in 2 separate recent decisions on June 10th, 2026 and October 3rd, 2025, specifically stating on June 10th, 2026, the Appellate Division and In Re SD long ago made clear that any policy of a brick-and-mortar casino, even those outside of New Jersey, that forbids a gambler who self-excluded from a different casino is an indirect collateral consequence and beyond the Commission's jurisdiction to ascertain and enforce. On October 3rd, 2025, similarly, it was stated, "I cannot allow appellant's lack of diligence to circumvent the purpose of the self-exclusion. The explicitly waivers and acknowledgments that appellant clicked through to effectuate her sign-up were there to provide notice to the appellant of the consequence that would occur by signing up for the self-exclusion. This initial decision is contradictory to both of these previous decisions and sets up a dangerous new precedent. The division is not creating a new self-exclusion period or modifying the patron's election. The appellant himself selected the 5-year period. The division merely gave effect to the appellant's own selection. In the SD case that was cited in the initial decision tried to distinguish SD from this matter. However, the underlying principles here are the same, and the legal principle is the same. SD occurred before the internet self-exclusion program even existed. The self-exclusion here, like in SD, was voluntary, and the appellant admitted on the record that it was a voluntary self-exclusion. Participation in self-exclusion carries consequences, even if later regretted. The fact that this case involves an internet self-exclusion enrollment rather than an in-person lifetime exclusion does not diminish the voluntary nature of appellant's actions or the division's obligation to administer the program consistently. Additionally, it was cited in the initial decision that the business decisions of the casino operators were an issue. Independent business decisions made by the casinos explicitly set forth in the clear self-exclusion notifications were followed here, and some of the casinos chose to ban the patron. And the patron was well aware of this, that this could possibly happen when he signed up for both of his self-exclusions. It was listed in the acknowledgments that he himself went through and reviewed. The use of the word may demonstrates that exclusion from land-based properties is not an automatic consequence and not one that is imposed by the division. Appellant's personal belief that he thought exclusion was online only cannot override the written acknowledgments that were accepted. Individual operator policies, rather than mandatory action by the division, is what occurred here. The SD decision stated that SD's recourse lies not with the regulator, but with the individual casinos which have implemented responsible gaming programs that exclude him from their establishment. Further, the initial decision repeatedly focuses on the practical effect that appellant was unable to access certain brick-and-mortar casinos after enrolling in the internet self-exclusion list. However, the relevant legal question is not whether third-party operators chose to impose additional restrictions, but whether appellant knowingly and voluntarily enrolled in the internet self-exclusion list, which he admitted himself that he did. The record demonstrates that he did as well. Appellant completed the enrollment process, accepted the required acknowledgments, and selected periods of self-exclusion. The fact that casino operators later exercised their discretion to honor that exclusion at physical properties does not render the enrollment invalid. The disclosures were clear and were acknowledged by the appellant. Moreover, the record reflects that not all casino operators treated internet self-exclusion enrollment identically. The initial decision itself notes that certain casinos' relationships and restrictions differed among operators. This inconsistency further demonstrates that the brick-and-mortar consequences were the result of the individual operator's policies rather than a mandatory action taken by the division. Accordingly, the initial decision improperly conflates the division's administration of the internet self-exclusion list with independent business decisions made by casino operators. Because the division neither imposed nor controlled those land-based access restrictions, the existence of such restrictions cannot provide a legal basis for removing appellant from the internet self-exclusion list. Business policies of individual casino operators regarding access to properties are not controlled by the division and have no bearing on whether the appellant voluntarily enrolled in the New Jersey Internet Self-Exclusion Program. For these reasons, the division respectfully requests that the commission reject the initial decision uphold the division's final decision, and affirm that the appellant remains subject to the 5-year internet self-exclusion period that he himself admitted that he voluntarily selected on 2 separate occasions. Thank you.
Questions for counsel?
Not at this time.
Not this time.
I take it that EG,
Who's not?
we're just confirming that EG is not present.
Not present. Thank you. Thank you. Okay. Okay. No questions at this time. Is there a motion?
As the examiner of EG, I move to adopt the initial decision pursuant to NJAC 1-18-6, and find that the appellant should be removed from the New Jersey Internet self-exclusion list after March 6, 2026.
Is there a second?
I second the motion.
Any further discussion?
Yes, if I may.
Please.
I apologize, because I'm going to be a little long-winded. Let me start off by saying that the right to gamble in New Jersey is not a constitutional right. And that comes from In Re SD, a published appellate division opinion, 399 New Jersey 107. Now, I'm not saying that a casino licensee's decision and the division's management and agreement to exclude someone from a gambling in a brick-and-mortar casino in New Jersey should not be scrutinized carefully. That's what we do. What I am saying is that the scrutiny of that decision is not the scrutiny afforded to a violation of a constitutional right, and I'll get back to that in a little while. And from my perspective, at the ground floor of this issue is what I believe to be the regulatory authority for a casino licensee to exclude someone from its casino premises via the Internet Exclusion App, and that is NJAC 13:69C-1.2 A and B. I'll paraphrase and quote. It is the policy of the division to require that all establishments wherein gaming is conducted in this state, and I think they're talking about brick-and-mortar casinos, to be operated in a manner suitable to protect the public health, safety, morals, and good order and general welfare of the state of New Jersey. I think they're talking about responsible gaming. And responsibility for the implementation and maintenance of a suitable manner of operation rests with the licensees. That's the casinos. Now, I realize the regulation that speaks of internet gaming self-exclusion, NJAC 13:69G-2.2, doesn't say anything about being excluded from a brick-and-mortar casino, just New Jersey internet gaming. And I realize there appears to be 2 exclusion lists, one for brick, one for mortar, one for brick and mortar, one for internet gaming. And I further realize that if a person wants to self-exclude from a brick and mortar for 1 to 5 years, they could do it on the division's website. But if a person wants to self-exclude lifetime, got to come down to Atlantic City or Trenton and request that in writing. But if a person wants to exclude from internet gaming in New Jersey, all that person has to do is complete the process of an electronic app on a phone or computer or through the division's website, and I'm quoting, through his or her internet gaming account using strong authentication. And that is NJAC 13:69G-2.2. A simple check, as the ID recognizes, like it or not, that's what the regulations say. But it becomes an issue when the person finds out, or should have known, that an electronic self-exclusion gets him booted from brick and mortar. So I get the inconsistencies, I get the layers, and I get that along the way, the 2 separate exclusion lists and their separate processes have gotten meshed and are less than perfectly clear. And I get the concern that internet exclusion leading to brick and mortar could be better explained on an app better explained on the division's website, and maybe better thought out in terms of how those two separate exclusions are accomplished and how excluding from one could lead to the exclusion of the other. But it can't be denied that NJAC 13:69C-1.2, the regulation that charges casino licensees with maintaining public health, safety, morals, and good order and general welfare of New Jersey, of the state of New Jersey within its brick and mortar casinos, is giving casino licensees the discretion to exclude internet self-excluders from their brick and mortar casinos. And in fact, NJAC 13:69C-1.3 says that a casino licensee could be fined, or worse, for failing to exercise discretion and sound judgment to prevent incidents which might reflect on the reputation of New Jersey and act as a detriment to the industry. That's verbatim. Could they be talking about letting a problem gambler come into their casino when they shouldn't? Maybe. So wouldn't disregarding an indication that someone could possibly be a problem gambler be a failure to exercise discretion and sound judgment? I think so. In my view, the discretion afforded by the regulations to the casino licensees to exclude electronic gaming self-excluders from brick and mortar casinos is driven by two concerns, if you will. One, furthering the tenets of the policy for responsible gambling contained in NJAC 13:69O, as well as comporting with their duty to ensure the safety and morals and good order of New Jersey as contained in NJAC 13:69C-1.2. And a more realistic concern, if you will, avoiding lawsuits. And I have a unique firsthand view of that concern, because I was on the casino floor at Bally's for 20 years behind the tables. And I can recall on more than one occasion a gambler suing Bally for allowing him to keep playing at the tables, keep losing his money, when Bally's knew or should have known that he had a gambling problem. Disclaimer time, I'm certainly not saying Bally's did that, or should have been sued, or that the gambler's claim had merit. That's my disclaimer. But claims like that were filed. Civil actions, essentially a claim of negligence for failure to exercise discretion to exclude a problem gambler. That was the argument. Now, getting back to our matter. Let me firstly touch upon a nuance I don't think anybody mentioned that was brought up in the hearing and pops up regularly. I recognize that the regulations were changed so that electronic self-excluders are no longer asked whether they have a gambling problem when completing the self-exclusion process on the app or the division's website. Some apps still have that question there, I think like Jackpot. Now, some people interpret the absence of that question or the absence of an affirmative answer to support a self-excluder who claims he or she was confused, really didn't want to self-exclude, or didn't realize that self-exclusion was going to lead, or electronic self-exclusion was going to lead to brick and mortar. The argument goes, well, he never said he had a gambling problem when he self-excluded. That shows he really didn't want to self-exclude. And I know that's not what happened here. What happened here was a little bit different. The appellant said he had no ability to opt out of that question when he answered yes, which shouldn't have been in there in the first place. So the fact that it was there, he was prejudiced by that in the division's eyes. I get that. But in my view, let's be honest. Whether there's a question there or an answer there, isn't it reasonable for a casino licensee to infer that a person who excludes from internet gaming in the comfort of their own home, their basement, isn't reasonable for a casino licensee to assume that that person may be a problem gambler, even if they're not required to admit it? Isn't that a reasonable inference? I think it is. And if that's a reasonable inference, wouldn't a casino license policy to exclude internet self-excluders from their brick and mortar also be reasonable? All right, we get to the decision. And with all due respect to my colleague, the first issue I have is that the ID indicated that EG's position was that he only wanted to self-exclude from online gaming. I'm going to quote the ID at page 15. It is clear to me that appellant voluntarily placed himself on the internet SEL. Appellant testified credibly. He placed himself on the internet SEL because he wanted to be excluded from internet gaming dash and only internet gaming. I gotta say, I hear that all the time, and I believe it. And while that may be true, what he said, here's what E.G. also said on page 17. He emphatically said that he acknowledged he did not read the warnings, the ones that told him if he excludes electronically, he may be excluded from brick and mortar. Here's what he said, and I quote, "I should have read the fine print there. I mean, there's no other way around it. It falls on me, and I should have read it. It's my fault." So again, and with all due respect, I don't see how E.G. could be removed from SEL based upon the fact that he only intended to remove himself from electronic gaming when he emphatically admitted that he didn't read the warnings that he could be excluded from brick and mortar. Second issue of which I had to do with the ID's positions taken on the timing of the two self-exclusions. Now, I think this is what really drove the decision in this case in granting removal, even though it wasn't explicitly said that way. Ms. Dianantis, are you on the edge of your seat yet? I need you to please help me out here and let me know if I have this right. According to the evidence of record, E.G. excluded from FanDuel at 6:01 p.m. on March 6th, and the division confirmed that sign-up on 10:46 a.m. on March 7th for 1 year. Is that correct?
That is correct.
On March 7th, 2025, the evidence of record shows that E.G. self-excluded from Jackpot for 5 years at 1:53 p.m. Do I have that right?
Again, that's correct.
So the second exclusion for 5 years takes place about 3 hours after the division confirmed the first self-exclusion. Is that right?
Yes.
Now, here's a big if, and I didn't understand this, so help me out with this one. The ID reasons that E.G. shouldn't have been allowed to do the second self-exclusion because, according to the ID, I'm on top of page 18, during oral argument, the division stated that once a person is confirmed by the division for placement on the internet SEL, they are precluded from accessing their online accounts. That doesn't sound like 24 hours. Did you say that?
That's not correct. They would be locked out from, in this particular matter, the appellant would have been immediately locked out from his FanDuel account when he self-excluded. Then the list is given to the division at approximately 10:45. Then at noon each day, that list goes out to all of the operators. Once
Okay.
the operators receive that list at approximately 12 p.m., they then have 24 hours from that time period, based on the regulation, to lock each patron out of their accounts. So all of this timeline in this specific matter was all within the regulation. At 10:45, we received his FanDuel self-exclusion. The division then made the self-exclusion list for that day. We transmitted it to all of the operators, which is approximately 29 separate operators have to receive this list. And then once they receive that list at noon, they then have 24 hours from that time period to make sure that these individuals are locked out of their account. They can no longer wager, they can no longer even enter their accounts. So all of that happened within the regulation here. Additionally, we were able to speak with all of the operators after this, and we found that the longest that any of the operators took was 6 hours. So it didn't even take 24 hours. The longest they took was 6 hours to implement the self-exclusion and to be able to lock this patron out of their account.
All right, I looked up the regs myself, and I researched 13:69G 2.3, and it says, A, the division shall maintain the self-exclusion list and the internet self-exclusion list. B says, for internet self-exclusion, changes shall be made within 24 hours after the notice is transmitted to the division. Do I have that right?
Yes.
So according to the transcript, the division confirmed the self-exclusion at 10:46 a.m. on March 7th. That sounds like when notice was transmitted. So by regulation, the way I read it, unless I'm wrong, The division had until 10:46 a.m. on March 8th to notify all the other casino licensees. Is that right?
Correct.
But EG self-excluded for 5 years the second time from Jackpot on March 7th, 2025 at 1:52, only 3 hours after the division confirmed the first exclusion. Is that right?
Yes, and they would have had 24 hours from that time to be able to, in theory, to be able to access his other accounts.
Okay, thank you. But let's say for the sake of argument that the system failed. Not by days or weeks, not that it failed here, but let's say it failed 24 hours. That's basically the reasoning. If EG shouldn't have been able to access Jackpot to exclude for the second time, the 5-year exclusion doesn't count. Respectfully. That's like saying that a guy who enters a store in the middle of the night to rob it gets caught, admits he wanted to rob the store, can't be held responsible if the store owner left the door unlocked. If the door wasn't unlocked, he couldn't have taken the stuff, even though he admitted he still wanted to steal. Now, let me extend that simple analogy to a more formal one, to a principle of law which I am quite familiar with, and we're going to come full circle on the constitutional thing. The ID's reasoning in that regard sounds a lot like the fruit of the poisonous tree principle of constitutional law. And I know not everybody knows what that is, so I'm going to tell you. It's a common law evidence doctrine. Common law meaning a judge made it up. It's still the law. And it's aimed at protecting or remedying a violation of a constitutional right by excluding evidence derived from an unconstitutional search or seizure or a violation of Miranda. Let me give you an example. Let's say a police officer didn't have the legal authority to search a suspect's car, but he does anyway. He pops open the trunk and he finds a dead body. Under the fruit of the poisonous tree doctrine, the evidence of that dead body doesn't come into evidence. It can't be used to prosecute the person for murder because it was only gotten by the primary illegality of opening that trunk when they didn't have the right to. So anything connected to that primary illegality doesn't come in. So just like but for the police unlawfully entering the vehicle, the dead body would have been found, again, respectfully, to me, the ID sounds like it says, but for having access to Jackpot app, which he should not have had, he never would have been excluded for the 5 years. But here's the difference. Nobody's going to jail here. I love to say that. Nobody's losing their freedom or property. There's no due process here, and there's no constitutional rights. I'm guided by the General Rules of Administrative Law, NJAC 1:1-15.1, which says, evidence rulings shall be made to promote fundamental principles of fairness and justice and to aid in the ascertainment of truth. And I take that to apply to both sides. And C, parties in contested cases shall not be bound by statutory or common law rules of evidence, like the fruit of the poisonous tree. So on that point, I must part ways too. Lastly, I'm almost done, and with all due respect, I had some difficulty reconciling the policy concerns in the ID to support the decision to remove EG from the SEL when I look at the regulations. Reading from the middle of the first full paragraph on page 19, the ID says, in my opinion, banning patrons from being able to engage in any gambling when they made it clear they only want to exclude themselves from internet gambling does not further the policies of the Act, nor advance the statutory goals of our comprehensive responsible initiatives. Again, I'm not sure how EG made it clear he only wanted to exclude from the internet when he admitted that he didn't read the fine print. It falls on me. Continuing, the ID says on the same page, Submitting an application that takes seconds to complete, has no timeouts to ensure the fine print is read by the patron, and is confirmed only by a click of a button, does not, in my opinion, ensure those signing up for the Internet SEL are doing so knowingly. They will be banned from brick and mortar when the intention of the Internet SEL was stated to apply to Internet gaming only. Moving to the bottom of page 20, I also find it particularly concerning that Internet SEL signups primarily occur through a licensed casino gaming entity or affiliates, as opposed to patrons being directed to the division's website. Well, the regulations on both of those accounts say otherwise. But anyway, after reading these policy concerns, which I admit I share to some degree, I first asked myself again, did EG voluntarily exclude? Well, at page 15, the ID says, it is clear to me that appellant voluntarily placed himself on the SEL. Okay? Second, I ask, were the warnings that self-exclusion may lead to brick and mortar adequate? I gotta say they were, because again, on page 17 of the transcript, EG acknowledges their adequacy by inference when he says, I should have read the fine print there. I mean, there's no other way around it. It falls on me. I should have read it. It's my fault. Isn't he saying that they were there, but he just didn't read them? Now, despite the fact that I find the warnings are adequate and that EG voluntarily self-excluded, could the warnings have been clearer? Yeah. Can the division's website be modernized or more intuitive? Yeah. Could additional frictions, such as a mandatory pause or an enhanced stop prompt, be built into these apps? I'm not a tech guy, but sounds like they could. And could the division consider regulatory amendments to better harmonize the two exclusion lists and reduce this recurring problem? That is a decision for the division outside of my purview, but I respectfully suggest that such clarification through amendment would be helpful. Those potential improvements do not change the dispositive circumstances that EG voluntarily self-excluded. He admitted that he didn't read the warnings. The warnings were sufficient. There's no evidence in this record that there was a problem with the app or something like that. So putting that all together, almost done, I'm obligated to assess the self-exclusion issues here against the regulatory framework as it presently exists, like the framework that allows a person one click to self-exclude, and I quote, through his or her internet gaming account using strong authentication. That is NJAC 13:69G 2.2. I can't assess this with the mindset of the way I wish the regulations read, or I wish that the app had stop signs, or what I wish was on the division's website. And that brings my analysis back to the governing regulation, NJAC 13:69C-1.2, which provides that the authority to operate a casino, and critically, the responsibility to do so in a manner suitable to protect the public health, safety, morals, and good order, welfare, general welfare of the state rests with the licensee. In other words, the way I read it, the regulatory framework places the duty of ensuring proper operation, including compliance with exclusion requirements, on the casino operator, albeit managed by the division and in concert with their regulations of promoting responsible gambling as contained in NJAC 13:69O. So in my view, removing EG from SEL based upon this policy issue raised again, which are well taken, in my view, would usurp the casino license's authority to nullify its discretion to exclude patrons as it sees fit and as authorized by regulation. Those are my comments.
Thank you, Commissioner Formica. Commissioner
Mr.
Mahoney?
Chairman, yes. For the record, I was the interviewer on this particular case. I'm not looking to be quoted next week as my colleague is being quoted in several of the EG's statements. I reviewed the application. I spoke with the applicant. And EG touched the one-year button. That's what the conflict is about. He touched the one-year button. So my motion stands as it is, as the examiner. And my colleague did make some statements on things that need to be looked at, and I agree with him on. But at this point, I do not agree with what my colleague stated, which was a whole lot of lawyer information. And I stand by what I came about. Thank you.
I just have a few questions. The 29 people you notify, you said the longest it takes somebody to adjust their list is 6 hours. What's the shortest?
I'm not sure of that. We just went back after this particular matter. I'm not sure if it's the longest in every specific instance, but in this particular matter, we were able to interview each of the 29 operators and found out that the longest in this particular matter that any of them took was 6 hours to make sure that he was banned from all of his online gaming accounts.
And past practice, you've always, or the division has always went with a longer request for suspension?
That's listed on the division's website, and those words may, again, as Commissioner Formica indicated, may need to be adjusted. They aren't particularly clear. However, what happens is we allow them to run concurrent. So both terms are going to, for this particular appellant, both terms are going to be satisfied. The one-year term now has already expired, and the 5-year term will continue running from the date that he selected the self-exclusion. So we don't ignore one particular term or find that one prevails over the other. We allow them to run concurrently. However, in the sense of a problem gambling aspect, if someone chooses a one-year self-exclusion, as he did in this case, and then has overnight the time to contemplate his decision, and then make the decision that he needs a longer term, he's able to do so. And even once a specific patron is locked out of all of their gaming accounts, they're always able to go to the division and request a longer term. So even if they can't do so through their online accounts, they can come to the division and request, for instance, if they selected a one-year term previously, and then after contemplation, they decide they need a longer term or they want a longer term, they can always come to the division and choose a 5-year term as well.
Thank you. Any other questions?
Just following up on yours, Mr. Chairman, Ms. Dionantis. So a person who's self-excluded, either electronically or from brick and mortar, can always come down to the division and extend their exclusion?
Yes.
Okay, so do you see a difference between somebody opting for a one-year exclusion on a Wednesday and a 5-year exclusion on a Thursday?
I'm not sure I understand.
Okay. Is there, so if I opted for a one-year exclusion on an electronic app on a Tuesday, and then on Wednesday I went to another app and excluded for 5 years, is that any different than me lengthening my self-exclusion?
No, you could come at any time if you make that
Okay.
determination. You can then select a 5-year term 6 months later if you would like.
That's all I have.
No further questions? Nothing? Okay. So there's a motion on the floor to adopt the initial decision. Okay. All in favor, say aye.
Oh, is that high school?
Mr. Chairman, if you want, I can do a roll call vote.
Yes,
It's not
you have to do roll
required.
call.
But we do a roll call. And Commissioner Formica,
No.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
No. I believe we have another motion.
Yes. Thank you, Mr. Chairman. I have a motion to reject the initial decision in this matter, and I will reduce that to writing in due course for the
I'll-
reasons expressed.
I'll second that motion. Roll call vote?
Commissioner Formica?
Yes.
Vice Chair Molyneux,
No.
Chairman Pelosi.
Yes.
Item number 10. Consideration of the initial decision in the matter of the appeal of PS for removal from the self-exclusion list. That matter is docketed as 260046 AP. Again, we have Senior Counsel Pinelli to introduce you to that matter.
Chairman and Commissioners, Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is the June 10th, 2025 initial decision, June 10th, 2026 initial decision of hearing examiner for Mika in this matter. This appeal is from the Division's March 10th, 2026 letter supplemented by letter dated April 7th, 2026, final agency action denying PS's request to be removed from the self-exclusion list. After considering all the available evidence, hearing examiner for Mika found that appellant failed to demonstrate they were improperly placed on the list. You have the complete record in this matter, all of which is subject to the applicable confidentiality and privacy requirements. Appellant was notified of today's meeting. I would ask the division to enter their appearance and proceed, and respectfully remind all parties that appellant's identity is confidential.
Chairman, Commissioners, Gina Dianantis, Deputy Attorney General, appearing on behalf of the Division of Gaming Enforcement. The division asks that the full commission adopt the June 10th, 2026 initial decision in this matter. Thank you.
Any questions for counsel?
No, sir.
Okay.
No.
Is there a motion?
Yes, sir. Thank you, Mr. Chairman. I move to adopt the initial decision and find that appellant failed to demonstrate that he did not intentionally place himself on the New Jersey Internet Self-Exclusion List as required by NJAC 13:69G-2.2C, and deny his request to be removed from the self-exclusion list prior to his September 4th, 2026 expiration date.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, all in favor say aye.
Aye.
Aye. Opposed? Ayes have it.
Thank you.
Thank you.
Thank you.
Item number 11 is consideration of the initial Casino Key employee licensure and plenary qualification of Nagaraj Shighali to serve as Vice President of Information Security, IAM, for Marina District Development Company, LLC, doing business as Borgata Hotel, Casino, and Spa. I believe that counsel for the applicant has a motion to present. We have council president ask that they enter their appearances and address the commission directly.
Good morning, Mr. Chairman, Commissioners. Marie Jones from Fox Rothschild here on behalf of Mr. Shigali. With me today is, and I'd like to introduce to the commission, is Jaden McLaughlin, our summer associate at Fox
Oh,
Rothschild.
hi, congratulations.
I would like to respectfully request that we extend Mr. Shikali's temporary qualification for 1 month so that we can have additional time to discuss the report of the division with the commission and division staff. He actually had some delays, admittedly, in getting information to the commission, or I'm sorry, the division staff. He had some personal issues with his mother's health and his daughter's health. He has taken action now to get that information, has been working with the division staff, which I have to say has been excellent, and we appreciate their patience with this in getting various documentation and getting updates to the documentation that's needed. So, thank you.
Good morning, Chairman and Commissioners. Tracy Richardson, Deputy Attorney General for the Division of Gaming Enforcement. We were aware before today's meeting that there was going to be an adjournment request to extend Mr. Shigahali's temporary casino key employee license and qualification. I guess I do not object to that and had advised Ms. Fauntleroy beforehand that I would not object to that because we've submitted a grant recommendation to you all and it's in your discretion of whether you would like to extend that for the additional time. My only concern I wanted to address just now is that the reason asserted is to discuss the matter with commission staff and division staff during this month period. I am not sure what that means. We have included in the report certain items that we hinged our recommendation on for Mr. Shigahali to take care of in the immediate near future as far as documentation and amendments that are needed. Otherwise, there's not really any discussion that we are needing to engage in. Whatever the commission requires in order to make its determination as it sees fit is up to the commission, but I'm not really sure in between what discussions would per se be taking place. That's all I wanted to say. Thank you.
Thank
If I may, I can clarify that. That is to, in fact, get the additional information that the division has requested that he file, and if any, when I said discussion, if any discussions related to that were necessary. Thank you.
Thank
If I may,
you. Yes.
you did not speak to the DGA before you came here today?
Oh, yes, we have been speaking. We have been going through the Commission's counsel on the adjournment and request, but we knew that Ms. Richardson was not going to object to it as well. We have been in communication.
Yeah, I was just talking about today, period. You had the conversation before you came here today. I know you've been in discussion with them, but I mean, were you in discussion with them before you entered here today?
With respect to the adjournment, yes.
Okay.
Any other questions for council?
No, sir.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. This time I move to grant the petitioner's request to adjourn this matter to extend the temporary casino key license and qualification of Nagar. General Counsel, can you say that name for me?
Mr. Shigahali.
Mr.
Go with the
Shi-
last name.
Mr. Shigahali, I thought Italian names were tough, to August 12th, 2026, subject to the conditions contained in NJSA 5:12-85.1 and NJAC 13:69C-2.6.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote.
Commissioner Formica.
Yes.
Vice Chair Molyneux.
Yes.
And Chairman Pelosi.
Yes.
Thank
Thank you.
Thank you.
Thank you.
Thank you. Item number 12 is the joint petition of Harrah's Atlantic City Operating Company LLC, Boardwalk Regency LLC, Tropicana Atlantic City Corp., and William Hill, New Jersey, Inc., requesting a waiver of the residency requirement for casino key employee William H. Wentz III pursuant to NJSA 5:12-89B4. This matter was initiated by petition PRN 1732602 dated June 19, 2026, requesting as indicated the residency waiver on Mr. Wentz's casino key employee license. You have counsel for the properties, as well as Mr. Wentz, present, as well as division counsel. And with your permission, Mr. Chairman, I ask that they enter their appearances and proceed.
Good morning, Chairman, Commissioners, Beth Sacco, Vice President, Chief Counsel, Caesars Entertainment Regional Operations for the petitioner.
Morning.
Good morning again, Chairman and Commissioners. Tracy Richardson, Deputy Attorney General for the Division of Gaming Enforcement.
Morning.
So as Ms. Fauntleroy mentioned, this is a petition for a waiver of the New Jersey residency requirements for a casino key employee license for William Wentz. William Wentz is the Senior Director of East Coast Operations for William Hill, New Jersey. William Hill, New Jersey is a affiliate of the three Caesars Atlantic City properties, and they have the license to operate the sportsbook operation for the three Atlantic City casinos, as well as for Monmouth Racetrack. Each sports book has its manager, the mandatory position, which has a casino key employee license. In Mr. Wentz's oversight role, he needs to retain his casino license, but he also oversees East Coast operations, several jurisdictions other than New Jersey. So it's really not a mandatory position, which requires New Jersey residency, but it is a position that is discretionary within the company. This residency waiver, he's been a New Jersey resident since 2018 when he had his casino key employee license, and he is, due to personal reasons, he needs to relocate to Pennsylvania. And that's why this waiver is being requested. And unless the commission has any questions, we would respectfully request that the New Jersey residency waiver be granted for Mr. Wentz's continuation of his casino key employee license. Thank you.
The commission has the division's response of June 26, 2026, not objecting to the residency waiver. Essentially, as outlined by Ms. Sacco, Mr. Wentz in 2018, when he got his casino key employee license, he was going to manage the sports book at Monmouth Park Racetrack, obviously an on-site supervisory employee. He was then promoted to the East Coast area manager, again with an oversight role, but more hands-on of the Monmouth Park Sportsbook, as well as the retail sportsbook outlets at the casinos in Atlantic City. Now he has been further promoted to the senior director of East Coast operations. So again, he still maintains a supervisory role, but is again one step removed from the oversight and hands-on presence in the retail sports book. So we do not object to the residency waiver to allow his move that he anticipates. Thank you.
Are there any questions for council?
No, sir.
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed the memo of General Counsel petitioned by Ms. Sacco and the division's email voicing no objection. At this time, I move to grant the requested relief, grant casino key employee license William H. Wentz III, Senior Director of East Coast Operations for American Wagering, Inc., a waiver of the New Jersey residency requirement as provided for in NJSA 5:12-89B.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote.
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes. Thank you.
Thank you.
Say an order reflecting the commission's action will be. Item number 12 is consideration of the plenary qualification of Amit L. Patel to serve as Senior Vice President and Regional General Manager West for Bally's Corporation. This matter was initiated by petition PRN 3482203, dated November 21, 2025, seeking the temporary qualification of Mr. Patel to serve in the capacity indicated. You considered the matter at your December 10, 2025 public meeting and granted temporary qualification reflected in Commission Resolution 25-12-10-18. The division has filed this plenary report. Now before you is consideration of Mr. Patel's plenary qualification. You have counsel for the property as well as counsel for the division. And with your permission, I ask that they enter their appearances and proceed.
Good morning, Chair, Vice Chair, Commissioner, Lynn Levin Kaufman, Cooper Levinson for Bally's Corporation and Premier Entertainment, AC LLC, also known as Bally's Atlantic City or Bally's AC.
Good morning, Chairman and Commissioners. Juliana Davis, Deputy Attorney General, on behalf of the Division of Gaming Enforcement. The division filed a report dated June 26, 2026, recommending the plenary qualification of Amit Patel to serve as Senior Vice President and Regional General Manager, West for Bally's Corporation. The division has also reviewed the draft resolution and has no objections. Thank you.
Yes, as stated by everyone, the commission granted the petition of Bally's Atlantic City and Bally's Corporation to have Amit Patel temporarily qualified to serve as Senior Vice President and Regional General Manager of the West. I have a bad sense of direction, but even I know, and as I mentioned at the temporary hearing, that Bally's Atlantic City is in the east. However, that west title does include the Mid-Atlantic region, which includes Bally's Atlantic City. We respectfully request the commission to enter the relief requested and grant plenary qualification to Mr. Patel. I also have reviewed the draft resolution and have no objection. Thank you.
Any questions for council?
No, sir.
Hearing none?
Mr. Chairman,
Sorry.
I wanted to say I'm very impressed with seeing Bally's in the news. They that seems to it will work for Atlantic City because they've really been in the news lately. So, thank you very much, Bally's.
Any other questions for council?
No.
Hearing none, is there a motion?
Yes, sir. Thank you, Mr. Chairman. I have reviewed General Counsel's memo, the division's report, the draft resolution. And at this point, I move to adopt the draft resolution, find Amit Patel qualified to serve as Senior Vice President and Regional General Manager, West for Bally's Corporation, in accordance with NJSA 5:12-85.1, NJSA 5:12-89B, and NJAC 13:69C-2.7.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
Hearing none, roll call vote.
Commissioner Famika,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Item number 14, consideration of the initial Casino Key employee licensure and plenary qualification of Kelly H. Jacoby to serve as Director of Finance for Premier Entertainment AC LLC, doing business as Bally's Atlantic City. Again, this matter was initiated by petition PRN 324-2501 that was dated November 19, 2025, seeking Ms. Jacoby's temporary key licensure and temporary qualification to serve as the Director of Finance. You considered that matter at your December 10, 2025 public meeting, granted the request, and as reflected in Resolution 25121015. The division has now filed its plenary report. Same counsel for Bally's is here, and counsel for the division is here as well. And with your permission, I ask that they enter their appearances and proceed.
Yes, Lynn Levin Kaufman, Cooper Levinson for Bally's Atlantic City. I also would like to have the opportunity to have our summer associates that are here today introduce themselves.
That's the whole gang.
Brad Lomax, Rutgers Law School, Econ 3.
Chris Garofolo, Rutgers Law School.
Sean Doherty, Nova Southeastern Law School.
Zach Maddock, Elon Law School.
Mr. Garofolo, any relation to the judge?
Everyone asked that, unfortunately I'm not.
It's too bad. He's a great guy.
Okay, good morning again. As stated by General Counsel Fauntleroy, the commission granted the petition of Bally's Atlantic City for Kelly Jacoby to assume the duties and exercise the powers of Director of Finance of Bally's Atlantic City before plenary qualification and initial key licensure. We respectfully request the commission approve her initial key licensure and her plenary qualification to serve as Director of Finance of Bally's Atlantic City. I have reviewed the draft resolution and have no objections. Thank you.
Good morning, Chairman and Commissioners. Paulina De Araujo, Deputy Attorney General, on behalf of the Division of Gaming Enforcement.
Division submitted a report dated June 30th, 2026, recommending the initial Casino Key employee licensure and preliminary qualification of Ms. Jacob for Premier Entertainment AC LLC. Division has also reviewed the draft resolution and has no objections. Thank you.
Any questions for council?
No, sir.
Hearing none, is there a motion?
Yes, sir, thank you very much. I reviewed General Counsel's memo, the division's reports, the draft resolution, and at this time, I move to adopt the draft resolution and grant an initial Casino Key employee license to Kelly H. Jacoby pursuant to NJSA 5:12-89, and find Ms. Jacoby qualified to serve as Director of Finance for Premier Entertainment AC LLC in accordance with NJSA 5:12-85.1 and NJAC 13:C-2.6.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No, sir.
No.
Hearing none, roll call vote?
Commissioner Formica,
Yes.
Vice Chair Molyneux,
Yes.
and Chairman Pelosi.
Yes.
Thank you.
In accordance with Resolution 25121003, the next closed session shall be held on Wednesday, August 12, 2026, at 9:30 a.m. in the Commission offices.
This is the public participation portion of the meeting. Is there anyone from the public that wishes to speak? Ms. Fauntleroy, do we have any email comments?
We do not, Mr. Chairman.
Okay. Well, one, I want to welcome the interns that were here. Hopefully you had a few learning moments today here. And I want to thank all the division. We had a great turnout today all the way from the division. I see the chief left, though, Chris Kalam, but everybody else is here. So welcome again. It's always good to see you. And with that being said, is there a motion to adjourn?
Thank you, Mr. Chairman. I make a motion to adjourn the public meeting today.
Do I have a second?
Mr. Chairman, I second the motion.
All in favor, say aye.
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 Opposed? Ayes have it. Meeting's now adjourned. Thank you.